Good morning, everybody. I just wanted to explain a little bit about the postal rule. Now, this is a really powerful tool that you can use to control momentum in contracts. The mailbox rule, or the postal rule, refers to the default rule in contract law for determining when an offer is accepted. Under the mailbox rule or the postal rule, an offer is considered accepted the moment the offeree mails their letter, rather than when the offerer receives the letter. The mailbox rule originated in the British case of Adams versus Lenzel in 1818. In that case, the court determined that the buyer accepted the seller's offer to buy wool when they responded to the seller's letter, and not when the seller received the reply. So basically, Adams versus Lindell, the seller sent an offer to the buyer and said, "Hey, I've got wool for sale at a certain price. Would you like to buy this wool?" The response from the buyer didn't get to the seller, and in the meantime, the seller sold the wool to another party. So they went to court, and the court determined that the acceptance of the contract had been accepted when the buyer put his letter in the mail. So, and that has been a long-standing precedent. You put something in the mail, a contract is considered accepted, and therefore you then have a valid contract the moment you place something in the mail. So this is a very powerful thing that you can use to basically control what's going on in a contract, or in your going back and forth between yourself and anyone who's given you an offer to pay, or an offer to buy, or offer to sell, or whatever the case may be. So this is the secret when you're sending a conditional acceptance. You are sent, let's say you're sent a bill or a presentment. You're sent some kind of a document. Like, hey, you please pay, the cell phone company. Please pay the mortgage company. Please pay whatever. That's called a presentment. So you're presented with an offer to pay. What you can do then is conditionally accept their presentment, but also then create new conditions. Say, okay, I accept your offer to pay based on, certain conditions that you can place, and you can put anything you want on there. And the moment you put it back in the mail, you then have a valid contract. Not when they receive it. They don't have to agree to it. When they receive it, the contract is valid. So you can conditionally accept their presentment and create new conditions, which now alters the contract. This is called a novation. And then you send that back to them and make them sign for it via certified mail. That's very important, because that certified mail number is your contract number. So as soon as they receive it, unless they return it and say, "Hey, contract not accepted," or whatever, then you have a valid contract, and the contract number is your certified mail receipt number. Again, this is very powerful. Now, if they don't respond, they have agreed by signing to accept by certified mail your new contract. You have written despite not having read it. You basically rewrite the contract, and they have no choice but to accept the adjusted contract you wrote, unless they come back and rebut it or say contract not accepted. So if they just look at it, take your conditional acceptance, and file it and put it in the pile, or whatever they do with it, it lays on somebody's desk, you then have a valid contract with your conditions as the governing rule in the contract. So again, this is incredibly powerful. So now this is how you control the contracts, and they have to actively rebut whatever you send them. So, but the same is true that you can always turn around and send things back as well if you want. After you've opened it, you can just write no contract, rejected, or refusal to contract, cease and desist, or any other variation or rejection. But your best bet is to always turn around and go on the offense immediately by creating your own conditional acceptance. And I showed you in a prior video how to do a conditional acceptance, which you can see this right here. This right here, learning how to do this will put you in the driver's seat and give you the power when you're negotiating or resolving a dispute with a company. Another thing is that when someone mails you something and it has your all caps name on it, you can simply send it back. Send that back and say, hey, that person doesn't live here. You've addressed it to my all caps name. I am not that person. And you can also remember when they get you on the phone and they say, is this, John Smith? You can respond by saying, I am not that person. Do this with a bill collector. I am not that person. I am the beneficiary of the trust. So basically, you just act like they didn't mail you anything, or that they mailed you something from some completely random person you have never known or met. And when you respond like that, it totally messes up their whole system. And most of the time, the person on the other end of the phone, who is sent, there to call and act as a bill collector, they don't know how to respond to that. And when they put that in their notes, it totally just wrecks their plan as to how they're going to come after you. Another thing is that you remember that your abbreviated state in dealing with the mail, your abbreviated state like Alabama, AL, or Ohio, OH, that is a trademarked, and so that basically, when you address something and you put your state with the 2-letter abbreviation, you're using that trademarked name or abbreviation, and that is how the government gets jurisdiction over you. So what you can do is always put, when you're having anything mailed to you, always put care of, in care of, or C/O, which means in care of, before your address, to indicate that you do not actually live at the address. You do not, but you do receive mail there. This is smart because the entire mail system has been subverted. So when you use that 2-state abbreviation, you're giving them jurisdiction. Or the zip code, same thing. Anytime you use a zip code, that is a postal zone. That is a federal zone number that you are saying, I live in this zip code. I am under this jurisdiction. So you have granted them jurisdiction by putting your zip code on there. What you can do is to put the zip code in brackets. If you put it in brackets, that takes that zip code, it takes it out of the contract. So by putting your state abbreviated and the zip code, you now have placed yourself into a federal zone. And this is not good, as this is how the federal government gets jurisdiction over you. Now, there is a way around this. By using the 4 corners rule. This means you can put brackets around the things you don't want to contract with. For example, 123 Main Street, California, 91202. You put it in brackets. Just put brackets around that zip code, and you're basically saying, I'm taking this out. I am not contracting with this. So that protects you in a powerful way by protecting you from coming under the federal jurisdiction. So the brackets basically allows you to put the information in the address without it being contractable. So you can put brackets, or you can do care of, and you can also, I always use a P.O. box or some kind of a paid mailbox to prevent you from having to say you live in a certain place. You can also use the brackets and make sure you always spell out your state in full. Always put the long form of the state. If it's Alabama, don't write AL, put Alabama, 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 Ohio, same thing, Texas, whatever the state is, never abbreviate that. Always make sure you spell it out in full, and also avoid the zip code as much as you can, or put it in brackets. So now if you use care of, then you can avoid all that because you are not admitting to living there. Proof of where you reside, having an abbreviated state and zip code, is what you want to avoid. This becomes proof that you are a U.S. citizen, and therefore you are subject to their jurisdiction. You are giving them authority over you when you address anything by mail like that. So don't do it. Hold all power. You hold all power in your hand by simply making sure you respond to anything important that might be sent to you. The whole point of certified mail is to have evidence that they actually received the parcel. So the only way any bill or lawsuit can hold is by you failing to rewrite the contract by conditionally accepting it, then sending it back with a signature required. So the minute they send you any kind of a contract or any kind of an offer to pay or whatever the case may be, this works with everything, then you can create a conditional acceptance. And you know, I keep a template, and I can edit that template as needed to change the conditions of anything that is sent to me, and then send it back via certified mail, addressed with the state written out in its long form, the zip code in brackets, which keeps me from contracting with the federal zone. You can totally, when you do that, you totally just wreck their system. And so how many times have we done that? You'll get a bill and it's from some toll authority or some this, oh, you got to pay this. And, you know, rather than rebut it, you know, you just turn around and pay the thing. So you definitely want to not do that. Always return a conditional acceptance with anything that you don't agree with. So when you send a conditional acceptance, you can also send via certified mail registered copies to the attorneys general of the state and also the federal attorney general of the United States. And you can see that that's what I did here with this conditional acceptance. You know, I will, depending on what state, I'll put the attorney general here with a, you know, certified mail return receipt requested, and then I'll put you know, the U.S. attorney general, and so what that does is it draws them in as witnesses. And when they sign for the parcel, they have agreed by doing so that they are witnesses to the new contract. And this is so powerful because it corners the original presenter into agreeing with your novation, because these are all powerful people that have witnessed that this was served on them. And in fact, if there ever was a lawsuit, you can call the attorneys general in as witnesses to testify, and they have to because they are public servants or trustees. And for them to fail to do this is for you is trust fraud, as you are the beneficiary. They have, if they don't come in and testify, then they have violated trust law. because they are trustees. You have made them trustees when you put them as witnesses. And the attorneys general and, these various public officials, they are trustees of the public trust, and you are the beneficiary. And that's why it's important to learn how to stand up for yourself, so that you then can call them and say, I need you in court next whatever. I need you in court to testify that this was that this conditional acceptance was sent. And because it is unrebutted, then it becomes truth in commerce, and it will stand in any court. Incredible. The mail is extremely powerful when you know how to use it to your advantage. Sending back these conditional acceptances are also an excellent way to start building your case. So you should always be thinking in your head as you're going back and forth with anybody that you are building a case and you are putting evidence before the court. Because remember, all of this, if it's unrebutted, or even if it is rebutted point by point, if you end up in court, if you end up in front of a sheriff's grand jury, you're going to have all of this as documentation, and anything that has not been rebutted point by point is going to stand as truth in commerce. That's the law. So when you decide to litigate as the plaintiff, or if you are sued as the defendant, you will be ready to pounce immediately into aggressive action because you've laid all the facts out there. And when you send them all of the mail and the conditional acceptances that have gone back and forth, you place that into evidence before the court. Your case is basically already proven before court even gets started. So remember, this is important. Human beings are always senior to corporations. Only humans can autograph affidavits. Humans inside of corporations have to stick their neck out to sign affidavits for their company. So make it dangerous for them to stick their neck out. And so that no one in the company would ever dare fix their signature to an affidavit, and you become a king or queen, and literally anything you say in your conditional acceptance becomes truth in law. Bills disappear, lawsuits fall apart, even criminal cases can fall apart with no effort when you use this method. The postal rule, extremely powerful because you are in control. And one of the things that I like to put in my conditional acceptances, I'll always tell them, when I send a conditional acceptance, I'll always say, listen, mere declarations are insufficient response. Always state the response must be via commercial affidavit, because what that does is it puts them on the record for their company. So I've sent this to CEOs and presidents and different ones that say, I'm like, okay, don't just send me a letter. You have to respond via commercial affidavit with a notary seal affixed, because what that does then, if there's anything in what they've said there that is not correct, let's say it's an error in accounting on the bill, anything they say then, and they've affixed their notary seal, the notary seal to a conditional acceptance, which makes it a commercial affidavit, they have then just committed perjury. And they can be prosecuted for that. They can be held liable for perjury. So anything you sign like that becomes, it's the same as if you're standing before a judge and placing your hand on the Bible and raising your right hand and declaring this to be the truth, the whole truth, and nothing but the truth. So if there's anything wrong there, or any error or omission, then they have committed perjury. And these people are smart. They know better than to put themselves on the record like that. So a lot of times, or in all cases, what I'll do if someone's sending me a bill or a presentment, I'll say, I have not seen any sworn affidavit that would provide validity to your assessment of the accounting of this bill. And I do not believe that any such paperwork exists with this. Well, I have never had anyone send me back a sworn affidavit because they're not going to stick their necks out. And so by using these principles of the postal rule, extremely powerful, it puts you in charge, it puts you in control, and you can basically get them to do whatever you need them to do by using the postal rule. So thanks for listening. I hope you guys enjoyed it, and I hope you learned a lot, and I'll see you again on the next video. Thanks a lot. Bye-bye.